fresh with the thing. Much all.
Yeah, please, Your Lordship. Lordship, consider the other side effect. You mentioned item number 5, Your Lordship. In this matter, we have filed an affidavit. As per last matter, we were asked to file a detailed affidavit, Your Lordship. So we require 2 weeks time to file a detailed affidavit, Your Lordship. Fine.
Let it reach. Let it reach.
Services are not complete.
Yeah.
Okay.
Let's see, Your Lordship. I'd like to mention item number 15, Lordship.
Item.
Number 15, Lordship. On 5. Maybe adjourn for today, Lordship. Adjournment slip already been submitted yesterday, Lordship.
Adjournment slip was submitted. Huh?
Maybe list on this Friday, Lordship.
Okay, on request made by Mr.
BLESK, Lordship. On behalf of BM Deca.
On request made on behalf of Mr. BM Decker, then counsel for the appellant. List after 1 week.
Lordship, with the consent of the appellant side, Lordship, I basically mentioned item number 30. Lordship, in this case, Lordship, I am paying for 2 weeks further time for filing the reply. Lordship.
Okay. Item 30, list this case. Before any other bench without one of us. Within bracket, justice, you can.
May it please your Lordship, my lord. Item number 20, my lord. Perhaps, Lordship, this is Naya, my lord, like to take up, my lord. Lordship said appeared for the writ petition and in the writ petition.
Item 20, no?
20, my lord.
Same order. Leave this case before
Alright.
any other bench without one of us.
May it please your Lordship. I'd like to mention an IA for listing on any day as per your Lordship's schedule. An
Next
IA
week?
stay.
Next week.
Is anything?
18th.
I'm grateful. Your Lordship.
Please, Your Lordships, I beg to mention an I for listing, Your Lordship, for condonation of delay. Any day next week, Your Lordship.
Okay. 6 Monday.
Much obliged, Your Lordship.
Please, Lordship, I beg to mention item number 12. Already adjournment slip is given yesterday.
Yes.
List after 1 week.
You are Mr.
See Talukdar.
You are appearing on behalf of?
Petitioner.
Okay. On request made by C. Talukdar. Then the counsel for the petition, for the applicant. Please come to one.
Deep level.
May I please, Your Lordship? I beg to mention item number 25. My humble praise to adjourn the matter for today and fix any other date after 2 weeks.
Your good name?
B. Borua,
You are appearing on behalf of?
S. Borua.
On request made on behalf of S. Borgohan, then the counsel for the petitioner. When do you want?
After 2 weeks.
After 2 weeks.
Item 1 and 2 of daily list order.
May I please, Your Lordship?
Sorry, my lord, I was.
Barboya.
My lord, I find a writ appeal, my lord, to be listed on Friday, my lord.
Why?
Because the urgency is that, my lord, I filed way back in the month of March, my lord. Due to some defect, my lord, we have rectified it, my lord.
Okay.
Friday, my lord.
May I please, Your Lordship? One of respondent died.
Respondent
yeah,
one.
One of respondent Lordship.
You have not
We
done your
file
substitution yet.
application Lordship, sir. So kindly possible for the day. We need some more time.
How much time you require?
1 week, Lordship.
MS. RB Bora. Learned
Junior company.
junior governor. Appearing for the applicant. Is allowed 1 week time to file an appropriate application for bringing the legal representatives of the respondent number 1 on record. List after.
One of respondent. I do not know whether 1 or 2, Lordship.
I think it's respondent one.
Respondent number 1 in 185. Read appeal.
1 in 1.
In
Sure.
185. It happened. 185.
I'm for the only private respondent.
List after 1 week.
Deeply, please.
Yeah.
3.
I don't know. 4, 5, or 6, 9.
three.
456.
Three. Lordship, we have taken steps, Lordship. The service report has not returned back, Lordship.
That was on 6/9/2024. No,
Lordship.
no. You took the steps on
Newly implemented party because the Hojai College has been upgraded to a university. So we have
on
to-
8/8/2024. Should be await service report. Await service report on the respond number 4586. And list after 2 weeks.
And a copy of the amended petition has not been furnished.
Furnish a copy.
Lordship, only the, I'll furnish Lordship.
Four.
My lord, in this case, the suo motu contempt, my lord, last, forest department has to, my lord, give it the latest.
Who is
latest report.
respondent number 3? Who is appearing for respondent 3?
Forest department, my lord.
Lordship, I am afraid.
You are appearing. Where's your affidavit?
Lordship, we have submitted the latest report up to January. For the next one, Lordship, we are seeking 2 more weeks because the DFO has some personal difficulty. In 2 weeks, Lordship will file the latest status.
Okay. Mr. D. Gogoi.
I brought no.
I brought. Learned counsel. Appearing for the forest department.
Lordship,
How much time
2 weeks.
is allowed? Another 2 weeks time to file affidavit in terms of the order dated 28.
My lord,
List of the weeks.
deeply.
5.
So notice,
Notice to say as part of office note dated 30/2024, received the neither ID card nor the answer note has been returned back in this.
when did you take service?
It was been issued on 5/6/2024. As part of office note dated 5/6/24. Notice was been issued to our own.
So what do you want to do? You want to
No,
take
counsel-
first steps?
No, sometime maybe before admin lordship, there is an OL lordship.
1 minute. On the respondent number 1.
One.
No, this is writ appeal. He's your employee, isn't it?
Lordship?
He's your employee only. Respondent number 1.
Yes, lordship.
Then can you take dusty service?
So we can, yes, lordship. Yes, yes, lordship.
Okay. The appellants are permitted post service of notice on the respond number 1 by dusty service to the registry of this court. Within a period of 1 week,
1 week.
after appellant shall find an affidavit with that effect. List after 3 weeks.
Yes.
6.
Yes, Khataniyar,
Yes,
regularization done.
done, madam.
Yes,
Also, specific direction was for area salary. Matter will be kept pending till area salary is released. That's it. Direction, contempt petition page 18, lordship. Is that
That will see. Then we keep it pending for some time. But Mr.
MQ, sir?
Learned counsel for the petition. Mr. N.G. Catania, learned counsel. Representing the sole respondent. Has produced an order dated. What date is this?
8 minutes. What is the date of this order? It's 5/9.
5/9/2024. Issued by the Secretary to the Governor of Assam, Department of School Education. Whereby the regularization of the termination period of the petitioner with effect from 21/5/2012 to 18/1/2014 was recommended. Stop. He has also produced another communication dated 10/9/2024 written by the Director Secondary Education Assam and addressed to the Inspector of Schools NDC Nalbari, wherein it is stated that the government has recommended the regularization of the termination period of the petitioner with effect from 21/5/2012 to 18/1/2014. And therefore, the Inspector of Schools NDC Nalbari was requested to take necessary action from your end, to take necessary action and to submit the error salary proposal for the period of termination. Stop. The said order dated 5/9/2024 and the communication dated 10/9/2024 is placed on the court. Stop. By the next date fix, Mr. N.G. Catania, then a counsel for the respondent shall place on record as to whether the error salary of the petitioner has been forwarded to the government, to the concerned authorities by the Inspector of Schools in this now. This after 2 weeks.
Yes, fine.
Seven.
Your Lordship, on 2nd of August, we directed to take steps on respond number 6 by registered post and Dusty. It took steps, Your Lordship, as indicated by the office note dated 12/8. We could not take Dusty because the appellant was the resident of Bihar. Now, the latest office note report indicates that neither AD card nor unserved notices have been received from respond number 6. Maybe fresh steps or maybe Dusty, as Your Lordship may direct.
8/8/2024. You did not take Dusty?
We did not take Dusty, Your Lordship. We could not take Dusty because the appellant is past his retirement age. He's a resident of Bihar and there was some difficulty for him to travel. But he took the liberty from this honorable court. But we've taken registered steps.
Yes. So what do you want?
I'll leave it to Your Lordship to maybe take steps again. Or maybe a liberty to also take a Dusty.
We can always service the court. Mr. M. Sharma and the counsel for the appellant submits that the appellant could not take steps on the respond number 6 by Dusty. Inasmuch as she has retired and presently residing in
Bihar.
Bihar. He however submits that the notice on the respond number 6 has been taken by registered post on 8/8/2024. So, our service report on respond number 8.
6, Your Lordship. 6, Your Lordship. 6.
On the respond number 6, you corrected. On the respond number 6, at least the matter after 2 weeks.
2 weeks. I'm grateful.
H.
You also notice.
This was 2029 second time.
Make it zero.
Bunny?
Well, the service on respondent number 4 is not complete yet.
It was taken in the month of July.
Yes.
You want to take first steps?
We can wait for the service report. Not for
It's already more than 1 month.
Karimganj, madam.
Karimganj.
It will take some time.
Take some time.
It will take some time. So we await service,
Await service report.
await service report on the respond number 4.
The interim order may be
And
continued.
released after 2 weeks. Interim order partially to continue till the next one.
Bless the children.
9.
May it please, my lord. My lord, the engaged counsel is on the way. Kindly take up this matter after some time.
Where is he?
He's on the way.
Which site? This contempt, I don't think it's maintained.
Court has adopted fresh proceedings. To feel something. Here it is substantial.
Yeah.
Who is the counsel?
FZ Majumdar. After some time. Problem.
10.
Service is not complete, not sole respondent. Office note indicates that neither unserved notice nor ID card is in returned back.
Issued in May.
What's it?
It was issued in the month of May.
In the
notice.
month of March, April. 13/4.
No, 31/5/2024.
Well, I'll take first step here. I'll
This
take-
is Gale, Leonard counsel for the petition, for the appellant. Is, no, so cancel it. The appellant is permitted to take first steps for service of notice
Sole respondent.
on the sole respondent by registered post,
Last.
by registered post AD within 1 week. It's not after 4 weeks.
11.
Made to judge. Well, this is a appeal preferred by the state, madam. While preparing the appeal, madam, there was a delay of 949 days, madam. Well, line of friend is appearing for the response number 1.
The file an objection, Malad.
What about the notice on respondent 3?
In respect of respondent 3, I think since the date of provincialization, the 1/1/2013, he is no longer in the school. I don't know what the service, most probably that person is no longer interested. That is my view, Malad. And I am suffering because during the pendency of the contempt petition for implementation of the order, they approached this honorable court after lapse of 949 days. Malad, it's I file an objection, Malad. I am suffering, Malad, due to this situation, Malad. I am expecting to get provincialization, Malad. Malad,
Yes, Katanya,
Yes, madam.
there is no.
what about the notice on respondent number 3?
Because judgment order dated Malad 22/1/2019. It is
Okay.
highlighted at the Malad now Malad,
Uh,
they oppose this honorable court. Malad, it's required to be dismissed, Malad, on ground of delay, Malad.
Registry is directed to place this matter before the Lawazama court with regard to service of notice on the respond number 3. List after 2 weeks.
Obliged.
13.
Notice.
159 delay, Lordship.
What about notice?
Lordship, notice was already received, Lordship, in the last office note, Lordship. You can see it. Notice received,
Notice received.
Lordship.
Are you sure?
Lordship, the last office note, Lordship.
6/9/2024.
Lordship.
Neither ID card nor answered notice in respect of this phone number.
Lordship, I will take it.
Okay, the applicants are permitted to take first steps for service of notice. On the sole respondent, isn't it? On the sole respondent by registered proceeding within 1 week?
Lordship.
1 week. This after 4 weeks.
14, admission.
May I please, Your Lordship? This appeal involves only one point, whether appointment of the second son, mother is liable to get, not to get the pension.
That was already discussed by the learned single judge.
Yes, discussed, my lord. But to my submission, my lord, that's why we have come before your lordship, my lord. Till the death of the mother, I suppose that she is entitled to pension. Now, till the date of the joining of the second son on compassionate grounds, thereafter pension has been stopped. They said that you will not entitled. I do not know, in my appointment letter, there was no mention that my appointment is subject to the not to get the pension to my mother. My brother died on 10/5/96. Then my mother applied.
1 minute.
10/5/96. Then my mother applied, my lord. But during the process of pensionary benefit, my mother died on 18/10/2003. So I being the only son, I was given appointment, my lord, on 22/12/98. Then, my lord, I have claimed the pension being legally next to kin of my family, the aerial pension of my brother. Then Honorable Single Judge has granted up to, my lord, 98. That is 96 to 98, I will get the pension. Thereafter, I will not get pension because I got a job. Probably that proposition is not liable to be, not correct, my lord, to my submission.
There was a life when he got the job.
Notice.
Things the son would be able. Yeah.
Lordship, Mr. Agili Chaudhary is in Lakes in port number 5.
Okay. You can
Notice
appeal.
have issued, my lord.
You can appeal. You are appealing for?
All respondents.
Union of India, Madam, अपना कोई
All respondents are due.
all respondents. sir.
You heard SCB source, then I call for the petition. MS
L. Devi Lordship.
L Devi,
On behalf of Mr. Agili Chaudhary.
CGC. I'll record your name, it's same, then as CGC. Appears on behalf of all,
Yes, Lordship. From
all the
respondent 1 to.
stop. Notice on the respondents are complete. List for admission hearing after 1 week, 2 weeks,
1 week.
after 1.
Yes.
16,
Yes, Majumdar. No affidavit.
No, my lord, the affidavit is in fact required, my lord. The rule is under challenge, my lord.
Which
Rule 28, my lord, of the 2018 rules, my lord.
secondary education?
My lord.
Anybody for secondary education?
In negligence, not.
No, my lord, elementary.
You are for second reading. Yes, where's your affidavit?
In this matter, we need to file our affidavit. 1 week time may be given, Your Lordship. Affidavit is ready. It's sent for vetting, Your Lordship.
Okay, heard Mr. Maguyan, also for the petition. MS.
ADAS.
ADAS, then standing counsel,
Yes, Your Lordship.
secondary education. Is allowed 1 week time to file up, no draft. List of-
May I pray for a date, my lord?
Why?
Because, my lord, last 3 times they have taken time for affidavit, 3 dates. My lord. Objected, my lord.
Okay. 20 September.
My lord. Obliged.
17.
Lordship. 16. 17. Listed up to one, non-appearance for the applicant. For the petition. List up to one.
18.
Lordship, this is a PIL on the last date when an objection was raised with regard to maintainability, Lordship, by the Demarcation.
Yeah, please.
Yes, sir. I'm appearing for Demarcation, Lordship. Notices may go. Notices may go.
Last time you raised some objection on the maintainability.
Yes, Lordship.
So why should we issue notice?
Then Lordship may pass it for time being, Lordship. My senior is on the way, Lordship.
I don't understand.
The facts are not similar, Lordship.
One side you said notice to go, one side again you want some other person's to.
Lordship, time being, Lordship.
For some time.
Okay.
19.
My lord, the point is, it's an alleged offense under section 179(1). And the procedure is prescribed in section 180. Speak it up on the.
There's one similar PIL.
Yes,
pending
it is
as
there,
on,
pending. It is
PIL.
fixed on 24th.
Lordship,
We have it together with that.
My lord will issue notice in this case and tag with that matter.
Lordship, may I submit, Lordship? In that PL 46 of 2024,
Hmm.
they have challenged the rule. Here, Lordship may kindly have a look the prayer of the PIL. Because in the conformity of the skeletal motor vehicle rules, we have doing all this. Prayer page 16, my lord. May I read, my lord? Their issue is that during the pendency of the challan, the department have to issue the pollution certificate. Lordship may kindly have a look 167 of CMB rules.
No, my lord, I am petitioner. My lord will kindly come to section 208 of the MVA.
Same thing is in the.
Yes.
Third KN Chowdhury, senior counsel, assisted by Mr.
TK Mishra.
DK.
far this PIL is concerned, I have some objection for maintainability of this petition.
Okay, we will keep
Because
the
my lord, this is a personal interest litigation, because my lord, the association, they have fighting in this PIL in their own rights, not for the public. Paragraph 3, my lord. They may file a writ petition, there is no bar, but not in the form of PIL.
Let my learned friend argue, my lord. I'll with that argument.
Yes, Hart Kian Chowdhury, Leonard Senior Counsel, assisted by Mr. DK Mishra, Leonard Counsel for the petitioners. Petitioner or petitioners?
Petitioners, my lord.
Petitioners.
Association and the secretary.
Issue notice. Transport Department,
Lordship, I am 4, 1 and 4, MD Bora,
MD Bora, Leonard Additional Senior Governor.
Standing Council Transport
Okay,
Department.
Leonard Standing Council Transport Department, appears for 1 and
4, my lord.
4.
I am for 2 and 3.
And Mr.
DK Sharma.
DK Sharma, Leonard Governor.
Additional Senior.
Additional Senior Governor. Appears for the respondents, 2 and 3. Copies of respondents, the complaints. Respondents are on the file. The issue of maintainability raised by the Leonard Additional Senior Governor Advocate is kept up. Please the matter on 24/9/2024 along with PIL number 46.
Obliged.
21.
Matter will be kindly passed over for the time being, 21. 21, no, sir.
21.
Yes, Lordship. Because Mr. MK should lead this case.
Behind you.
Yeah, yes, we are. I said, go here second.
I'm the respondent, my lord, with petition.
I said 28, 8 of 5. 28, 8. I should get the filing. I said, you get to. শিবের তো আমি ফাইল করার কারণে আমাকে হিসাব দিছে
Yes, sir.
My lord, a writ application was filed by the private respondent, lordship.
What is wrong with the judgment?
Judgment wrong, lordship. I have filed my affidavit in opposition on behalf of the appellant, lordship. So, lordship, when the matter was fixed for hearing, lordship, I have submitted my letter of absence, lordship, because I had a matter in the Supreme Court on 30th of July, lordship. So, letter of absence was also reflected in the cause list, lordship. Then, lordship, I have also annexed along with the letter of absence, lordship, I have also annexed the matter fixed in the apex court, lordship. Then, lordship, when the matter was called for hearing, lordship, none of the advocates of the appellant side were heard, lordship. And the matter that your lordship will find in the improved order itself. Page 191, it starts from 193. Page 193, the improved order, lordship. Here first at the top, your lordship will find the name of the edit petitioner, Mr. M.K. Chaudhary, M. Sharma, N. Goswami, the government advocate, S. Borua, government advocate, J.C. Handy, government. None of our names were also not shown, lordship. And the matter was disposed of. My limited prayer in the appeal is, lordship, this and lordship may come to the my letter of absence dated page 183, lord. Annexure Roman 5. Page 183, lord. Lordship, this is my letter of absence dated 29th of July 24. I have the honor to inform that due to an out-of-station hearing matter before the Honorable Supreme Court, I will not be in a position to conduct cases of part 1 and 2 on 29/7/92 and 30th/7.
You are appealing for the respond number 5, isn't it?
Lordship.
You were appearing for the response number 5
Yes, Lord.
in that writ petition.
Yes. I have
So,
filed my affidavit, Lordship.
On that day, one S. Barua was representing response number 5.
No, Borua was not mine. Only one new junior who is not an advocate on record, Lordship. She requested the honorable single bench that my senior is out of station. He is having a matter in the apex court. So this may be taken after 2 days, Lordship. So that was also not, her name is Priyanka Day, Lordship.
Okay, okay.
Next, Lordship may
Let
speak-
us see, let us see that you are not hurt.
Yes.
What is wrong with the direction?
The wrong is this,
It
Lordship.
is just that the demarcation to be carried out, position not to be disturbed.
Position,
That's all.
Lordship, a metro, a probate was granted by one of the brothers of the appellant and the private in respect of the same plot of land, Lordship. That will was executed and probate, it was probated in favor of the present appellant, Lordship, as a beneficiary. The writ petitioner preferred testamentary appeal with this honorable court, which is also pending, Lordship. There is not a single word whisper regarding my affidavit in opposition, Lordship, in the impugned judgment. Nothing else. Because there are two Supreme Court decisions, Lordship, in this matter that if any matter is decided without hearing the adverse party, Lordship, the matter should be reheard. That judgment I would like to place before your Lordship.
No. I don't think there's anything wrong with this.
Yeah.
This is the judgment 9081 to SCC Lordship, page 7088. Your Lordship may come to next page, second page. Second page, Lordship. Line, Lordship, from the bottom, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. But from the bottom line 13, Lordship. The same fact is there, Lordship. Problem that agitate us is whether it is proper that the party should suffer for the inaction, deliberate omission, or misdemeanor of his agent. The
You are
answer,
reading from which paragraph?
No, paragraph 3.
para 3,
Wow.
next page.
Which line?
Line, Lordship, from the bottom 13.
On the bottom 13.
Yes, it starts from the problem that agitates us.
Okay.
The problem that agitates us is whether it is proper that the party should suffer or for the inaction, deliberate omission, or misdemeanor of his agent. The answer obviously is in the negative. Maybe that the learned advocate absented himself deliberately or intentionally. We have no material for asserting that aspect of the matter. We say nothing more than on what aspect of the matter. However, we cannot be a party to an innocent party suffering injustice merely because he has chosen the advocate defaulted. Therefore, you allow this appeal, set aside the order of the High Court, both dismissing the appeal and refusing to recall that order. We direct that the appeal be restored to its original number in the High Court and be disposed of according to law. There is other judgment of the apex court, Lordship, reported in.
No. 1987.
Reported in, Lordship, 9087 supplement, Lordship, page 636. This is one page judgment, Lordship. Line 1, 2, 3, 4, 5. Line 5 from the top. Unfortunately, it is seen that the petitioner was not represented by his counsel at the hearing before the learned single judge. for whether, whatever reason the advocate might have absented himself at the hearing, the fact remains that the petitioner was not heard by the learned single judge. Similarly, and there is another Supreme Court decision which has been relied. We accordingly grant leave, set aside the judgment of the High Court, and remit the petition for disposal afresh. So I am only for this relief, Lordship. It can be disposed of by giving a direction to the learned single judge to dispose of the reheard the matter. And Lordship, I did not remain absent, Lordship, because I had a matter in the FS court. I have filed my letter of absence, Lordship. I have also annexed the cause list of the Supreme Court showing that my matter is fixed there on 30th of July. Here also, I have also annexed the Supreme Court cause list, Lordship. In spite of that, and apart from that, suppose Lordship, the learned single judge dispose of the matter without hearing me. But why the learned single judge choose not to discuss anything about my affidavit in opposition? Not a single word in the impugned judgment. Lordship, please to peruse my affidavit in opposition. What? Because section 100 of the Assam Land and Regulation, Lordship, provide that when there is a civil dispute, the a revenue officer cannot interfere. That, your Lordship, Supreme Court cause list, page 184, Lordship.
Anyway, these are different things.
Yeah, page 184, Lordship, see. One item. Supreme Court, 9 number. Click लगाना.
Here, item 20.
Page Lordship 188, item 24. Supreme Court, Lordship, page 188, item number 24. Assam Small Industries Development Corporation versus Micro and Small Enterprises, Lordship. In this matter, I was representing the Lordship, the respondent number 2 in the FS in the SLP, Lordship.
Okay.
My limited period, Lordship, the learned single judge should reheard. Lordship, see my affidavit in opposition, nothing.
No, but you satisfy us. How are you prejudiced by this?
Prejudice, Lordship,
even if you're
in
not heard.
respect of the will which was provided in favor of the petitioner, Lordship, against that the writ petitioner who filed the writ, Lordship, had filed the testamentary appeal, which is pending. That is, and 2 numbers of civil suits are also pending, Lordship, in respect of the landlordship. And the writ petitioner got Lordship file a partition petition, Lordship. And in that petition, only preliminary decree has been passed. Till date, no final decree has been passed. In a partition suit, Lordship, a preliminary decree is passed, Lordship, that cannot be executed until and unless the final decree is passed after receiving the report of paper partition by the revenue authority.
Yeah.
The submission of my learned senior friend is, my lord, that he was not heard and an adjournment was not given. My lord, that belies the order of this honorable court, my lord, or the honorable single judge. Firstly, my lord, your lordship has already noticed for respondent number 5, Mr. S. Burwa, the learned counsel, appeared. So that has been recorded in the order. Against that, my lord, his submission is that, my lord, he is not an advocate on record.
but I was also there in the, my lord, before the honorable single judge. No prayer was made for adjournment. That is number one. Now, my lord, secondly, he says that S. Burua is not an advocate on record. And he says that the opportunity was not given to him for hearing because he had filed an application for leave, and that was reflected in the order sheet. He had a matter in the Supreme Court. Now, my lord, this matter, whether, my lord, this issue, whether if a lawyer, my lord, files an application for leave, and that is reflected in the cause list as a note, does it automatically mean that the matter will be adjourned? It does not, my lord. More so, when, my lord, there is a set of lawyers and one of the lawyers have appeared before the court. And secondly, in the Supreme Court matter, my lord, I'm sorry to say, his name is not there. If your lordship sees the cause list that my learned friend, senior friend has produced, my lord, his name does not appear. So he is also not on the, my lord, the lawyer on
Lordship,
record of that matter.
Lordship, I am having the certified copy of the Supreme Court
That is
judgment.
not, my lord, let us get confined to this, my lord, particular, the appeal, my lord. So if your lordship comes to the, my lord, grounds taken by the, my lord, appellant, grounds your lordship will find at page 30. If, my lord, by filing an application for leave automatically adjourns the case, my lord, then, my lord, I don't have anything to submit. And grounds your lordship will kindly see what are the grounds the appellant has taken. First ground is that the impugned judgment and orders was passed by the honorable single bench without hearing the appellant. As such, the impugned judgment is liable to be set aside and passed. Your lordship has already noticed, my lord, one lawyer appeared for the respondent number 5 appellant. Then, my lord, second ground, found that the honorable single judge did not at all consider the adjournments made in the affidavit in opposition filed by the appellant, and the impugned judgment and order dated was passed solely on the basis of the adjournments made in the writ petition. As such, the impugned judgment and order dated 29/7/2004 has caused failure of justice. Now, my lord, we'll go to the, my lord, order. What is the finding of the honorable single judge? Then, my lord, other points he has not argued, my lord, other grounds. Therefore, I will not go to the other grounds. Now, your lordship will kindly come to the order which has been impugned in the present appeal. The ground they had taken in the affidavit in opposition is the fact that since there is some litigation pending in the civil court, the revenue authorities do not have the jurisdiction. My lord, there is no material to show that the civil suit of the probate is in respect of the land which has been, my lord, directed to be demarcated. It is my statement with your lordship, my lord, that the land, a patta, in respect of which the demarcation has been, my lord, directed by the honorable single judge, that does not, my lord, relate to any of the suits or the probate. And my learned friend has not produced any document to show that this is the same land. And your lordship will kindly read, my lord, what is the order passed by the honorable single judge. It's a very short order. Paragraph 3. This court has duly taken note, I'm reading from page 193, my lord. The judgment of the honorable single judge. The court has duly taken note that notice was issued by this court on 30th of October 2023, and observation has also been made in the said order that there is an objection which was filed by the respondent number 5, and it was on account of that the demarcation proceeding has not been disposed of. This court also takes note that an affidavit has been filed by the respondent number 2, 3, and 4, wherein it has been mentioned that there is a civil litigation pending between the petitioner and the respondent number 5. So this was the ground, my lord. He said, my lord, he would have urged before the honorable single judge. That has been taken care of. Today, Mr. N. Goswami, the learned counsel appearing on behalf of the respondent number 2, 3, and 4, submitted on instructions that the demarcation proceeding was stopped on account of objection being filed by the respondent number 5 in view of the pendency of the title suit number 326 of 2019. This court has also perused the objection which was filed, as the same was made a part of the instructions which was submitted by Mr. N. Goswami, the learned counsel appearing on behalf of the respondent number 2, 3, and 4. The objection is based upon section 100
of the Assam Land Revenue Regulation 1886. This court has duly perused the provision of section 100 of the regulation. The said provision is in respect to a partition wherein it is stipulated that there is a dispute as regards the title over the property in question. The revenue authorities should direct the parties to approach the civil court and get a decree in that regard. So there was no dispute regarding the title. In the instant case, however, the issue involved is not as regards partition, but as regards demarcation, whereby the petitioner has sought that the land measuring 2 kathas 5.22 lectures covered by Doug number 850 included in KP Patta number so and so under Moja so and so be demarcated. Under such circumstances, the court is of the opinion that the revenue authorities can very well go ahead with the demarcation. However, my lord, your lordship will see the protection given to the appellant. However, in doing so, shall not disturb the possession of either of the parties, taking into account that there is a civil proceeding pending. Accordingly, this court therefore directs the circle officer, Guwahati Revenue Circle, that is the
Section
respondent number
100.
4, to carry out the demarcation as regards the plot of land measuring so and so, included in Patta number such and such, in Shahar Guwahati Part 7, by giving proper notice to the person of the in the boundary of the said plot of land, and thereupon show the respective boundaries of the said plot of land. The Honorable Single Judge further says, it is made clear that the possession of none of the parties should be disturbed on the said basis of demarcation proceeding. On the basis of the said demarcation so carried out, the respondent number 4 shall also prepare a minutes of the and duly circulate it with the petitioner. Now, my lord, pursuant to this order, my lord, the demarcation date notice has been issued. It has been fixed day after tomorrow, my lord. May I please see it on record? Tomorrow, my lord. Now, the facts are like this, my lord. The petitioner and the appellant and the my lord respondent are our brothers. My client, my lord, he resides in Ireland, and my lord, because of that, my lord, he has been trying to enclose the land, and therefore, my lord, he wants a demarcation only. Show the demarcation as per the patta. I'm sorry, my lord, this is an assessment. I didn't get the time to, my lord, the transfer, my lord. But there is then no dispute that it has been, my lord, notice has been issued. It will be demarcated. It will not prejudice anyone, my lord. The protection has been given. If he has in the meantime enclosed, that possession also cannot be disturbed by this demarcation. That has been the protection given by the Honorable Secretary. With these protections, my lord, the appellant will not be prejudiced in any manner. And my lord, I also say that, my lord, this land is different.
What is the date of this?
My lord, notice was kita circulated to give. Date has not been, my lord, given here, but my lord, we have been served, I think last week, my lord. My lord, my client was served a week before my last week.
Lordship, S. Burwa, in the improved order name of Mr. S. Burwa has been shown as advocate of the respondent number 5. Never any such junior was associated with me, and my humble prayer is, Lordship, may be pleased to call the writ application, Lordship. And if the name of the advocate for the respondent number 5 appears, Mr. S. Burwa, not only I will withdraw my appeal, I will seek apology, Lordship. But at no length of time, any S.
Then you
Burwa.
file a review.
Lordship.
You file a review.
No, review I can file, Lordship. But
You
the
file a review
And my lord,
instead
in
of
respect of this land, I have got a valid decree, my lord. There is no dispute to that in respect of this. land.
Lordship, if
So
that is a
will be on
preliminary
record.
decree, partition should,
What
Lordship,
is
first
the
of all,
decree?
preliminary decree is passed. Then, Lordship, it is sent to the revenue authorities for the perfect partition. And after drawal of the perfect partition, Lordship, again, civil code passes a final degree, Lordship, under the Partition Act.
The attempt of the appellant is to, my lord, grab his brother's
No,
property
appellant-
who resides in Ireland, my lord. That is the main issue.
The person who is resigning, he has no interest because it is the attorney holder, he is having interest only.
Even the attorney holder is a lawyer.
It's your choice. You want
Pardon?
to file a review, you can file a review.
Then lordship, it can be disposed of and condoning the delay if any in filing the defense.
Condoning the delay?
Yes, review is to be done within 30 days now.
That is a different thing. You withdraw this writ appeal?
Now then your lordship, please,
Liberty to
please.
file review?
No, my lordship, my humble submission is kindly submit, I have submitted 2 judgment of the FX to kindly dismiss my petition. Appeal.
Will pass orders. Dismiss.
Highly obliged.
Obliged.
We'll do it together.
May it please, your lordship. My lord, ONGC authority issued an NIT for hiring of vehicle. Now, my lord, our case was the so-called purported tender does not have any attribute of a tender. It was a lottery. That aspect of the matter, learned single judge did not deal with. On the contrary, learned single judge relied upon an earlier order of this honorable court, where the stand was that they have adopted the oil model, and that tender you have annexed, my lord. There it was a case of one person, one card. That was the policy. We have no quarrel with that. Now, for example, my lord, please come to the tender pursuant to which the judgment relied upon by the learned single judge. That is at page 233. And my lord will kindly come to page 248. Tender starts at 233. Please come to page 248. It's part of the ITB. Now 2.2 is the provision relating to bid security. Then my lord will kindly come to page number 254. It speaks of technical bid and commercial bid. Page 254. Then my lord will kindly come to page number 259. It speaks of award of contract. Then at page 275 and 276, which is the crux, where, my lord, evaluation criteria, eligibility criteria are prescribed. Please come to page 276. Technical requirement, experience, bidder must have so-and-so, so-and-so, so-and-so. So this is a tender. My lord, this was put to challenge, this was negative. How this judgment has got any relevance in our case? Now come to our tender, my lord. Please come to page number 94, the NIT starts. Please come to page 96. Straightway, lordship may come to page 97. 97. tender description, hiring of services of brand new 372 number of light vehicles, taxi for Assam asset for a period of 4 years on lottery basis. Now these are the category. Category 1, Bolero. Category 2, Bolero diesel. Category 3, Tata Yodha pickup. Category 4, Toyota Innova, only 1 number. Maruti Desire, 3 number. And Scorpio, 17 number. And maximum number is, my lord, that Mahindra Bolero, that is 278. Mahindra Bolero B4 diesel 28. Tata Yodha 45. Then my lord will kindly come to page 98. Draw of lots and methodology of award. Against the current requirement of 372 vehicles under the tender, a total of 500 applicants will be selected by the first round of draw of lot, that is shortlisted applicant. First 370 would be ranked as the shortlisted applicants, and rest 373 to 500 sequentially ranked as waitlisted applicant, category-wise waitlisted. Now, how it will be awarded, my lord? Application submitted by the applicant will only be eligible for those categories of vehicle selected by the applicant while submitting their application. Contracts will be awarded to the applicant selected through draw of lots, subject to availability of those category of vehicle at the time of draw lot, which have been selected by the applicant while submitting their application, and also to subject to fulfilling all conditions as stated in para 3 and 4. Then my lord will kindly come to page number 102. Now, what all are the requirements, my lord? Please come to 2.2 towards the bottom. On login to the application system, and after verification of the registered email ID and mobile number, the applicant shall enter the following. Basically, my lord, name of the employment exchange from where the card has been issued, validity date of the employment exchange registration, date of birth, etc., etc. Now, please come to the last column, my lord. Applicants falling under 18 to 55 years on the tender original closing date will only be allowed to participate in the tender. This is also arbitrary, my lord. I'll say why. Then please come to page 104. On top, applications from individuals having valid employment exchange card from employment exchange of any of the following areas shall be accepted. Is it permissible, my lord? On the face of Article 15. Then my lord will kindly come to page number 159. And my lord, that 159 point is not relevant. 160. Special terms and conditions. 160. Towards the bottom, self-driven light vehicle shall be driven by owner himself throughout the contract period, and owner has to give a written undertaking that if at any stage it is found that the vehicle is being driven by some other driver, the contract shall be terminated with immediate effect. Ownership light vehicle has been awarded to contractor. Contractor may hire another driver for driving vehicle. Now, my lord, these are the scheme. So the question is, my lord, how do we select a tenderer? What category of vehicle they will purchase, that is there. Only thing is, I need to be registered with an employment exchange, and I must be within the age of 18 to 55 years. Now, what is the other eligibility criteria? My lord, Supreme Court has said in a tender, there must be certain attributes. Now, kindly take the judgment, my lord, that Michigan judgment to the Michigan দুটা দিয়ে দেখুন দিন দুটা দিয়ে তাই বলি দিয়া Lord will kindly come to page 229, part of para 23, D. Page 229, para 23D. Certain preconditions or qualification for tenders have to be laid down to ensure that contractor has the capacity and resources to successfully execute the work. Now, I fail to understand how this process can be construed as a tender. It is bereft of the essential requirement of a tender. Now, learned single judge, my lord, recorded our submission, but learned single judge has not dealt with this point. Now, please come to the impugned order, my lord. It is at page 291. If your lordship would kindly, sorry, 44. Please come to my lord, page 47. Please come to page 49. Before that, page 48 for a moment, my lord. Para 3. The petitioner's counsel submit that the NIT lacks essential condition of tender to evaluate the eligibility of the tenderer. So this was my fundamental argument. So learned single just takes note of it. Then please come to page 49, para 5. Matter how many people have applied, that is not an issue. Issue is if somebody is agitating his legal right, that needs to be decided. Sri so-and-so learned senior counsel further submits that as on date, 19,000 tenders have been received for hiring 372 vehicles. He further submits that the processing of the tender would take a few months. He further submits that validity of the contract period between the petitioner number 2 to 13 and ONGC is valid up to December 24. He further submits that a self-driven, anyway, this was the submission. Now please come to page 50. On considering the submission made by the parties and keeping in with the fact that the change of policy by ONGC has not been disturbed by this court in WPC number so-and-so, this court is not inclined to grant any interim order in this case. My lord, in 6208 of 23, I have already said, my lord, there, if your lordship would kindly take that affidavit of the ONGC in that case, page 306. Page 306, my lord. Para 11, somewhere in the middle, my lord, the sentence starting with, and therefore to resolve the prevailing situation, has your lordship got it, my lord? Yes. And therefore to resolve the prevailing situation, the higher management of ONGC decided to adopt the model of oil liaison, which is operating successfully, especially for hiring of light vehicle in Assam. If you are adopting oil model, oil tender I have already placed. Now, where is that eligibility criteria? How do you judge who is a better bidder? How do you judge somebody's experience? How do you judge somebody's eligibility? Only by draw of lot. So therefore, my humble submission, my lord, it's an aspect which needs to be examined. By not giving an interim relief, my lord, now they will go ahead with the contract. What will remain to be decided? It's not a very big deal, my lord. It can be decided by next Monday also. It's not an issue which will take a lot of time. It's not a rocket science. So let them go ahead. They will not finalize. Lordship will hear the matter, at least on the interim matter. Or Lordship will request the learned single judge to decide the matter by giving us some interim protection. That is my submission.
As my learned friend has very rightly said, this is not rocket science. This is hiring of taxis. What has happened is this now. What the learned single judge has held is the very policy pursuant to which this NIT has been issued was put to challenge. And that challenge has been negated. And how this policy came about, unfortunately, we have not had the occasion to file our affidavit because immediately after the motion, this has been filed. If your lordships will have this one. But before that, before I place these documents, if your lordship will find, just come to the cause title of this memo of appeal. Your lordship will find
that the appellant number 1 is a motor union. Appellant number 2 and 3 are secretaries of the union. And thereafter, 4 to 13 are individual members. If your lordship will kindly come to the annexure 2 at page 88.
Number 2 key.
This is the list of their members. And your lordship turns to page 90, your lordship will find they have a total of 93 members. And each of these are existing contractors who have given on lease their vehicles. They are continuing and their contracts are subsisting till December. Now, as against this 93, assuming they have not annexed any authorization by or any resolution of the union. So we are not very sure how many are actually agreed. As against this 93 people, in respect of this tender, the tenders were opened on 27th of August. We have received 27,700 tenders. So assuming 93 are agreed, as against that, 27,700 people have participated in the tender process. And we have opened the tenders. Now, if your lordship takes up this bunch of documents, what had happened was there is this small group of people who were monopolizing. Now, there was a demand raised that this is only hiring of taxis. Everyone should get an opportunity. So there was a tripartite meeting held between the ONGC, various stakeholders, and the district administration. And if your lordship kindly turns to the second page of this bunch of documents, your lordship will find, after threadbare discussion on all the issues, it is decided that serial number 1, tender for single vehicle will be accepted for single individual through lottery. And last paragraph, your lordship will kindly note. Further, the district commissioner requested the ONGCL authority to review the matter at their level and come out with a rational solution that genuine demand of unemployment may be addressed. Now, pursuant to this, if your lordship turns the page, we have amended our very policy pertaining to hiring of vehicles. In the second paragraph, as per decision taken by EPC, provisions of integrated manual have been modified in respect to evaluation of tenders for hiring of light vehicles in Assam as per attached annexure. And your lordship will find the annexure at the next page. And your lordship will find at serial number 2, 1 applicant, 1 vehicle. And thereafter, serial number 3, draw of lots to be held. So now, since it is merely hiring of vehicles, we said that if we get large number of tenders, how do we decide? So therefore, draw of lots, because the price is uniform. Now, based on this judgment, which now they have annexed, in the writ petition, it was not even annexed. Next page, your lordship will find the judgment. This very policy was put to challenge. At paragraph 2 of the judgment, your lordship will find the challenge. It has not been.
Oh, it's in the complaint. Okay.
No. Your lordship will kindly turn to para 2. The 4 petitioners have instituted the present petition assailing the decision taken by the respondent ONGC authorities, which has been communicated to the petitioners by email dated 18/9/23, by which the invitation of so-and-so has been cancelled. There was an earlier NIT that had to be cancelled pursuant to the policy decision. Even before the bids of the tenders were open. The petitioners are also aggrieved by the letter dated 19/9/23 issued by the ED Chief so-and-so MM Services, wherein it has been decided to hire light passenger vehicles on 1 applicant, 1 vehicle basis at the rate offered by ONGC using draw of lots. This was the challenge. And this challenge has been negated. If your lordship kindly turns to page 8 of the judgment, the last page. Para 13, even the decisions taken in the tripartite meeting, that has also been taken note of para 13, and ultimately the repetition is dismissed. So the NIT is a mere consequence of this policy, change in policy. And the other interesting thing your lordship will find, now what they have questioned is two things. That draw of lots is impermissible. May I just point out to your lordship one thing? Unfortunately, I could not make extra copies. It will copy us. I have.
In continues to December, we can ask the judge to hear the matter after they file an affidavit and display. Mr. Chaudhary, you made a statement that the tender, the contract with the appellants will continue till
December, it is their own.
even if you finalize this tender in the meantime, you are not going to award contracts in.
The whole process will take several months.
Okay, what clarity? So till December 24, they will operate.
Their contracts will continue.
So even if these tenders are finalized, that will not amount to cancellation.
It might be over and above.
Neither does it, but they will continue.
They will continue.
And you say that it will take some time.
Yes.
Now, when are you finalizing?
Because this draw of lots is going to start from this 27.
You have not filed your affidavit in the writ petition.
No, because it was at the motion stage.
So no, the matter is fixed on 29. Can you file your affidavit before 29?
29, yes, I think we can.
We'll ask the honorable single judge to.
They may proceed, they will not finalize.
Not
Yes.
because Mr. Chaudhary, you are protected till December.
No, my lord. No, my lord, my learned friend is referring to this earlier policy. We are not against the policy. Some of the members of the association, in fact, was there. Now, our problem is, no, my lord, the basic issue is whether it is a tender.
The ABC participates in the tender.
Yes.
They will give vehicles. The vehicle would be Bolero, new one, Bolero, whatever it is.
Whatever.
Criteria. Now the rates, there is no dispute.
No, the rate is also fixed.
Rate is also fixed. So how do we
Rates
decide?
Cannot be a matter of evaluation, because that is already fixed. Now, if A Bolero vehicle is taken or a B Bolero vehicle is taken, how can this court say that is wrong?
No, my lord, what I am saying is,
How can
no, my lord, the tenders must have certain elements. One of the basic element is a person who gives, supposing, my lord, I am an existing contractor. I'll buy a vehicle in the name of my brother who is studying somewhere, and his name, the vehicle will be given.
But
then the purpose of tender would be defeated. My lord, now what will happen? They will encourage shadow tenderer.
It's a case of one applicant, one vehicle.
Precisely, but it will be shadow tender. My lord, it's somebody, Benami.
Subject to correction.
My lord, my learned friend is referring to that policy. We are not against the policy.
Fills that age criteria and the criteria with regard to the vehicle are open to participate.
My lord, question is, supposing there are two tenderers, two persons vying for one vehicle. Now, supposing, my lord, if some eligibility criteria is laid down, then based on the eligibility criteria, somebody will be preferred.
We can't ask them to lay down certain eligibility criteria.
Of course.
Their discretion.
No, my lord, it is their discretion which they have not exercised. That's why I'm before your lordships.
Your lordship, you just have a look at the previous tender. I've just given a bunch
My
of
lord,
documents.
please go by the recent
No, no,
judgment
no.
of the Supreme Court in MP Power Corporation, where Supreme Court has reiterated that I think time has come. We should not give this long handle to these respondents. My lord, we have seen in the state, my lord, they are laughing, sitting in dispute, that we are doing all these illegalities, courts are ignoring them. I'm with all sense of responsibility, I'm making this submission. Because on the ground of technicality, that it is the employer who will decide. At times, my lord, arbitrariness creeps in. Therefore, here is a case, I am raising a very fundamental issue. Is it a tender? Can it be? Lordship, give us a finding. If your lordship finds that it's a tender, I'll accept it. Prima facie.
That there is, it's not that tomorrow the tenders are going to be.
Oh, yes, yes.
29, the date is fixed. We'll ask them to file their affidavit.
Yes.
We'll request the honorable single judge to first adjudicate.
And my lord, till then, my lord, they will not finalize.
That way, he has already made a statement.
Lordship will record their submission.
He's already made that.
How long will it take to finalize?
Let him make his submission.
Take a few minutes. I was pointing out, just your lordship will kindly, that is why they have suppressed the document. Your lordship will come to the previous tender.
This one.
That bunch. Unfortunately, we were in a hurry, my lord, we could make only one copy. Your lordship will come to page 158. This lottery system, they have participated and they have got their contracts by virtue of this lottery system. What are they saying? Page 158.
Which is it?
This was the previous tender pursuant to which they have got their contract. Your lordship will kindly come to E2.
158.
158.
158 এর দেখা যাচ্ছে তাহলে
E2. In case there is a tie, even after following the above allotment procedure given in so and so, then a lottery shall be drawn.
Oh, tie lottery is a different concept.
Here there is a tie. Even when we invited tenders, there is a tie because earlier, the reason is this, my lord. Earlier, the rate was not fixed. If your lordship will kindly come to page 149, your lordship will find that the minimum reserve price was given, but the rate was not fixed. This time, what we have done is, assuming, my lord, that there are two identical vehicles we are taking. One costs 100 rupees, the other one costs 110 rupees. For the same identical vehicle, why should we be paying two different rates? So this time what we have done, that since the vehicles we have clearly mentioned, the rates should be the same. Let's say two Innovas we are hiring. The rates are fixed, assuming 3,000 rupees. So now, if everything is at par, how do we decide? Why we have a lottery? And that is what is permissible under the, if your lordship takes up the Representation of People's Act, section 102, even in an election when there is a tie, there is a lottery. Then under the Right to Education Act, the neighborhood has to be decided by a lottery. So where is the fault? This is only a tender for hiring taxis. So where is the fault?
We'll request a single judge to
Yes.
dispose of.
Yes.
We'll
For a
record.
moment, please come to page 299, Miller. 299, serial 12, that's the petitioner union, appellant union. What was our stand? Not to process tender on lottery basis. This is our only stand, Miller. Yeah, no, my lord. Yes. It's the part of their affidavit in the earlier case.
But that has been negated, and that is why the policy, and that policy was challenged and it has been dismissed.
My lord, my learned friend is repeating that sentence. My lord, we are not against that policy.
We are
Policy is very well.
recording your statement that the finalization is going to take few months.
Yes, possible record that.
Is that correct?
Exact time frame, it's difficult to say, but 27,700 participants.
So yes,
Lottery will take some time.
sometime is few months or 1 month, 2 months. At least give us some approximate date.
Couple of months, your lordship.
Couple of months.
Okay.
Done.
That is fine, fair enough.
What's ordained the agenda?
Deep.
Oh, 5 minutes. 5 minutes.
And there is one aspect I overlooked to mention, point out to your lordship. If your lordship will come to the impugned order, what was the submission before the learned single judge by the petitioner? Two sentences have a lot of. The impugned order starts at page 44. Your lordship will straight away come to page 47. The first sentence of para 2. The petitioner's counsel submits that the petitioners are all qualified to participate in the tender process. And in the next page, they said that these employment exchange cards that were asked for is violative of Article 15 or something. Second sentence in that para 3. In this regard, he has relied upon clause 3.0a of the NIT, which provides that the applications would only be accepted from individuals having employment exchange card from employment exchange, Sipsagar, Nazira, Sonari, Moran, etc. He, however, submits that the petitioners are not disqualified from participating in the tender process due to above clause. So the petitioners are not prejudiced in any way. The only problem is their monopoly will go. That is the problem. That is why they don't even annex a resolution of the union that they have been authorized to prefer this litigation.
15th of October.
15th of October.
You can file your affidavit before 20.
We will.
We'll give you a date. Say, 20 is the date fixed, isn't it? Can you file by 16th?
We will 16th, the lordship will fix it on 18th for filing.
They will also require time for reply.
Today we are already on
11th.
11th. We'll try.
Till 15 October, my lord, there is no any, my lord, further process, my lord. That.
So we'll request the learned single judge to dispose of before 15th of October.
There's no question of any interim order in this case. Clear?
Obliged.
Obliged.
23.
At your lordship, my lord. By filing this petition, my lord, we have, my lord, challenged the judgment and order of the Central Administrative Tribunal dated 21/11/2003. And the petitioner opposed the tribunal, my lord, and the inaction of the respondent authorities in not releasing our dues. Dues in the sense, my lord, our father was a railway employee and he expired. Then we are the children, daughter through second wife. Then there was a dispute arose, and accordingly, succession case was filed by the, my lord, second wife, the mother of the petitioners. Then she got the succession certificate declaring her to be the, my lord, legally married wife. That was put to challenge before High Court by preferring a appeal. And writ petition was, my lord, that was ultimately, my lord, dismissed with a direction for fresh examination of the matter by the district court. And accordingly, the matter was reheard. Decision was taken by the district judge and declaring the petitioner to be lawfully entitled to inherit 1/3 of the share of the, my lord, deceased father. Then at one point of time, in 2014, my lord, after long persuasion, the respondent authorities, my lord, directed us to produce all relevant documents. We produced the documents. And my lord, thereafter, my lord, we submitted several representations. Nothing happened, which compelled us to approve the, my lord, tribunal. And tribunal, my lord, basically, my lord, tribunal on 3 different points, my lord, was not inclined to interfere with the matter and dismiss the matter. Number 1, the, my lord, first wife, our stepmother, was not made party. And to that, my lord, effect, we submitted that she is not necessary party because we didn't make any claim against her share. Because we have been declared to have been entitled to 1/3 share each. And 1/3 share will go to the stepmother. Therefore, since there was no any claim against her share and she is not necessary party, that was not accepted. Initially, my lord, court put a question that there is a long delay and we are asked to file a separate continuation application.
Okay, we'll issue notice.
My lord.
Mr. A.K. Protest. There's counsel for litigation. Issue notice. Who appears for the union?
Pardon, my lord? Others railway.
Railway. Any standing counsel?
Mr. DJ Das was appearing. I will receive not.
DJ Robert. Yes. Mr. DJ Das.
Lordship.
No, CGC.
Sees lot.
On all?
Lordship, for the railway responsibility.
Railway. How about one? Same, all
All are railway responsibility.
appears on behalf of all the respondents. Stop. Notice on respondents are complete. You want to file affidavit? No.
Also, we'll file an affidavit because we are raising some maintainability issues out there.
Okay, Mr. DG Das, then it's CGC. Please, for how much time?
4 weeks ago.
4 weeks time to file affidavit. Praise a lot. List up to 4 weeks.
Much of it.
Of that, your lord.
I really apologize.
24.
May please, Your Lordship, but this PL summary has been filed for maintaining the basic amenities in the various religious structures.
Almost, my lord, affidavit from all the district has been filed except 2 or 3. Lordship, may I hear the matter picture there?
No, you
Not
wanted
eight-
to,
eight
in the last occasion, you wanted to file your affidavit.
Yes, my lord.
With regard to the
On only 2, 3 districts left, my lord.
remaining districts.
এখন আছে রাজু এখন আছে এই আচ্ছা
My lord.
Yes, total 8 districts are yet to be filed.
But I have to file ready for filing 4.
Fine. Let them complete.
How much?
4 is ready for filing.
How much time?
2 weeks, no?
But HK Das.
Other, my lord, other two district, they have no places, major religious places, 2 district. And are left 2 or 3 districts.
Karbi Anglong, isn't there?
Yeah. Biswanath Chali, they say they have no major religious places. Like Mankasa said, they have no major religious places.
That affidavit is already there.
Yes, please.
But the other, for the other remaining districts.
My lord,
you
we
are
will
taking
file.
Time for quite some time.
Yeah. Let it be after 4 weeks, lordship. In the meantime, we'll compare.
After the vacation, my lord will take up, my lord. In the meantime, they will complete.
HK Das, Leonard, Standing Council, Guwahati High Court. On request made by Mr. RK. RK Bora. Leonard, Government Advocate. Additional Senior Government. 4 weeks for the time is allowed to file affidavits in respect of the remaining districts. Stop. Please, after 4 weeks.
Deeply.
Deeply.
26.
Abu,
It's coming.
Arif.
Yes.
May I please, your lordships?
RK Bora. Yes, Bora.
Lord, matter relates to selection and appointment as an assistant teachers. My lord, in upper primary schools in the district, in the entire BTC area, my lord, in 2016 appointments. My lord, admittedly, and I have to submit fairly, my lord, before my lordships, my lord, that there are some sort of discrepancies while making the appointments. But, my lord, we have been appointed and make the status of a government employee, my lord. Now, the learned single judge, my lord, has categorically has gone through the every aspect of the matter, my lord, and in a very detailed judgment, my lord may be pleased to find the impugn order. Lord starts from page 407, my lord.
Yeah.
Lord, at page 407, the findings, my lord, starts from page 412, my lord. From the every annexure has been categorically my lord. My lord, from page 412, my lord, annexure 1 is a, my lord, document caption notification for advertisement. The said document bears an ineligible signature purportedly by the chairman, Nalbari District Secondary Education Advisory Board and Chief Borulan Executive Council, Kukrajhar. As per the contention of the said document, the date of receiving application was 37/2002 and the last date of receipt of application was 8/8/2002. The date of interview or selection in order of merit and locally was Guwahati Circuit House on 11/8/2002, date within which the approval from the BSC, that is the Boruland Autonomous Council Authority, should be obtained was 26/8/2002. I mean, what has happened in the entire findings of the judgment? The learned single judge has held that, my lord, that the hour selection was not in accordance with the rule. And, my lord, there are the records which has been maintained by the officials of the BTC, my lord, has also not very clear that in what manner we had been appointed. My lord, our case before the learned, honorable learned single judge, my lord, was that, my lord, there is a selection and a select list had been prepared, and there is a mandamus had been issued by this honorable court. There is an early order also, my lord, that the beyond the select list, no person should be appointed, my lord. And accordingly, my lord, basing on that select list and pursuant to the order of this honorable court, my lord, we had been appointed. And, my lord, while our appointment, after the appointment, my lord, again, my lord, writ petition has been filed by some unsuccessful candidates whose appointments were those who were not appointed, my lord. And there is an stay of our appointment in that writ petition, my lord. And accordingly, my lord, during pendency of this, my lord, petition before this honorable court, my lord, the impugn order has came to be passed. And before passing of the impugn order, my lord, admittedly, only just asking for a so cause notice, my lord. And we have replied to that so cause notice. And on receipt of the reply of the so cause notice, they have straight away terminated us from our services, my lord. The honorable learned single judge has held that as the entry, he has also categorically finds that the termination is also not in accordance with the provision of law, my lord. So once, my lord, that benefit has not been given, that the learned single judge has held that as the entry is not proper, so therefore, if the termination is also bad in law, my lord, there is no scope of interference, my lord. So my lord can hear the matter, my lord. My lord. It is a my lord.
Is the error.
My lord, error is there, my lord. We have in our grounds, my lord, categorically have shown that the error part where the error is there, my lord. My lord, kindly appreciate, my lord, we have not been, our appointments were not on pick and choose policy, my lord. Once, no, I have, that is correct, my lord.
It is the advertisement in persons.
No, advertisement, my lord.
Notification.
No, that is correct, my lord, but the record which had been maintained by the BTC, my lord, those records were not made available before the learned single judge, my lord. Now, my lord, kindly appreciate that for the, my lord, non-availability of the record, we cannot be suffered, my lord.
You want to hear the matter today or
Some other day, my lord.
some other day?
My lord.
Bora?
Any other day, my lord. Any other day, my lord.
Okay, on request made by the parties. List the matter after,
2 weeks, my lord.
after 2 weeks. Keep on extending your time.
My lord. My lord, once terminated, we
Yeah,
cannot.
you already terminated it.
My lord. Or my lord, may I pray, my lord, that the termination has not been by following the rules. At least one chance, my lord, that the Assam Service Discipline and Appeal rules should be followed in toto, my lord.
The one problem is that your entry itself.
No, my lord, entry, that's why, my lord, I have to submit fairly before my lord, my lord. There are it is not an illegal, irregular mode of appointment, my lord. That irregularity can always be regularized, my lord.
Supposing we interfere with the
My lord.
termination order,
My lord.
automatically you go back.
We can go back, but they have the power to again initiate.
That illegal appointment comes to force.
No, my lord, that is not my
That
case,
is
my
the
lord.
issue now.
My lord, if we go back, my lord, that does not preclude them to initiate a de novo proceeding for our termination, but that should be following the due procedure of law, my lord. That is our limited prayer, my lord.
Okay.
My lord.
27.
After some time, my lord, this will take it. After some time, my lord.
Why?
Because, my lord, I'm led by Mr. Bidida Senior Advocate. He's on live, my lord.
Some of them, my lord, early in the 1993 also. 1993,
1993.
prior to 1993 was there also.
The Dilip Talukdar's case does not apply to you.
That distinction is my senior friend Soman.
Okay.
Twenty-eight.
We are in dispute, my lord. File a affidavit, my lord, respond.
No affidavit, 1, 2, 3.
My lord, I received some instruction from the Home and Political Department and Legislative Department, my lord.
No,
They,
you file your affidavit.
my lord, that instruction is not sufficient for my lord filing the affidavit. They said, my lord, my lord, the case of the petitioner is that, my lord, there is no directorate for implementation of Assam Accord. But here, my lord, we have a directorate for implementation of Assam Accord. And the Home and Political Department and the Legislative Department instructed the Directorate of Official Language Implementation Assam. But they are not party in this proceeding. May I pray, my lord, for a proper adjudication of this matter? My lord, Directorate of Official Language Implementation Assam, they are the necessary party. That will help me to, my lord, provide instruction and filing affidavit.
You give him the address, then he can take steps.
My lord, my lord.
Mr.
A.N. Sharma, my lord.
A.N. Sharma.
A.N. Sharma.
A.N. Sharma, Land Council. For the petition. Press for making an appropriate application. Press for 1 week time,
My lord.
1 week time to file an appropriate application for improvement of the
Directorate of Official Language,
director,
my lord.
director
Directorate
of
of
official language
Implementation Assam.
implementation Assam. Press a lot. List after a week.
Obliged.
29.
Is the petitioner in person or is the?
Well, the-
1 minute. Are you the petitioner in person or the council?
I'm appearing on behalf of the petitioner in person. I'm appearing on behalf of him, my lord. He's at legs in court number 17, my lord. He's arguing a matter, my lord.
Heard, Mr. What is A.N.
A.N. Sharma.
A.N. Sharma.
Yes, ma'am.
Appearing on behalf of the petitioner in person. No, don't say her. Mr. A.N. Sharma appearing on behalf of the petitioner in person. Praise for a week's time, no? Yes, what?
well, this writ appeal issue herein. Well, against this judgment and order, we have preferred some other appeals. My lord.
Yes.
Those appeals are already admitted. This has come today, my lord, service is complete. Lordship may admit this appeal and tag it with the other appeals.
It's already admitted. It's already admitted on 1/4/2024.
Now, my lord, they are appearing, the other side appeal. Lordship, the other appeal is writ appeal number 50 of 2024. Yes, my lord. That is the main case.
Which appeal?
50, my lord, 50 of 2024.
But Mr. D. Nath, Leonard, Senior Governor Advocate, Assam. For the appeals. Mr. K. Patkari, Leonard Council.
Respondent number 1.
Interceptance on behalf of the respondent number
1, madam.
1. How many respondents are
No,
there?
others are pro forma respondents, my lord, they are official respondents.
Stop. On request made by the parties. List is writ appeal along with writ appeal number 50 of 2024. After
Let it come.
Already in part two here.
It is in the part two hearing list.
PA number
The other appeals are-
181.
Other appeals are in the list. It will come with that. After 2 weeks.
Right.
31.
My Lordship, I beg to appear virtually, my Lordship, for item number 31 on
Okay.
behalf of the petitioner, my Lordship.
We are
My
praying for,
Lordship,
we are praying for,
I appear for petitioner, my Lordship.
you are for the petitioner. And you?
Yes, my Lordship.
Huh? You are
What of
assisting
this?
My Lordship, may I start my submission, my Lordship?
1 minute. No affidavit has come, isn't it? Who's KL? And B Chowdhury?
Lordship, my senior is on late, Lordship.
And the state GST? B Chowdhury, standing counsel. State GST. We'll take up after some time, you please wait.
Obliged, my Lordship.
Opposite counsels are not.
32.
May I please, Your Lordship? I'm appearing on behalf of Mr. TJ Mohanta. Correspondent 1 and 2. The affidavit is ready and we have submitted before the registry of this honorable court for vetting, Lordship. Expect 2 weeks time. Within that time, we will file our affidavit.
Okay, heard Mr. A.B. Learned counsel for the petition. On request made on behalf of Mr. TJ Mahanda, Learned senior counsel. Appealing for the respondent.
Respondent.
How much time?
2 weeks.
2 weeks. For the time is allowed to file affidavit. List after 2 weeks.
Upright.
33.
Lordship, in this case, notice was issued and my friend is appearing for first time for respondent.
Respondent 1.
Yes,
Lordship.
Lordship.
Sole respondent.
Sole respondent.
You are appearing?
Yes. 2 weeks time may be granted to file my affidavit. Have come against the order passed by the law. Let's see.
Okay, heard Mr. P. Chalaparty, Leonard CGC for the petitioner. Mr.
Yes, Chaudhary.
S.
Chaudhary.
Chowdhury, Leonard counsel, enters appearance on behalf of the sole respondent. And prays for how much time?
2 weeks time.
2 weeks time to file up. Praise the Lord.
Lordship, there is an interim order that may be continued.
Was the same order? It's state. State. No, for the
34.
I'm led by my lord, senior operator, Mr. K. Chaudhary, my lord. He's on legs, my lord. Lordship, may kindly see the last order, my lord. At page para 8, my lord.
What did the tribunal hear the matter?
Yes, my lord.
Online.
And my lord, heard, my lord. This is my lord. I have given this my lord, matter has been heard, my lord, and my lord, it is kept for my lord for final judgment, my lord, in the MA, my lord. So, my lord, it CAV, my lord. So, my lord, may I pray for my lord fixing the matter on Monday, my lord. Because my lord, the contempt is also fixed on this 13th, my lord.
13th?
This, my lord, on Friday, my lord.
The old met, it's already heard, isn't it?
Yes, madam.
Your MA
Yes, my lord. Heard.
and adjustment reserve.
Yes.
So what more is left?
My lord, may I pray, my lord, for fixing this matter on Monday, lordship may dispose of the out on Monday, my lord. Since my lord, this judgment has not out, my lord. So, my lord. Because, my lord, because
Okay, Mr.
Z Goswami, my lord.
G Goswami, learned counsel for the
Petitioner, my lord. DSN.
submits that the tribunal had heard MA number 95 of 2024 on 9/9/2024, and the order has been reserved. Stop that. He, however, prays for listing this matter again on 16th of September. Accordingly, list the matter on 16th September.
Deeply august.
35.
Neighbors. This, in this case, my lord, the petitioners are actually claiming for the benefit of advance increment on account of procuring the B.Ed degree, my lord. What happened, my lord, earlier, this honorable court has set aside the notification dated 22/10/2014. And thereafter, my lord, the department has issued a circular whereby, my lord, they have decided to give the benefit of one advance increment to the candidates who are having the.
Are we going for a final disposal?
My lord, may admit it fix it for hearing, my lord. We have filed our affidavit, my lord.
A date will be given in that event after puja vacation month. For your lordship,
We are not ready.
I am not.
What happened, my lord?
My lord, may admit it and fix it for hearing after.
It's not, it's not admitted.
Not, it's in,
Not
in
admitted, my lord.
no, replies and counter affidavit always it's complete, my lord. What happened, my lord? Some of the petitioners are going to retire also in this. And Honorable single bench in huge number of judgments, my lord, already granted, and pursuant to those orders, the petitioners of those cases have also been given the benefit, my lord.
Judgments has kept the issue of the law issue.
Yes.
So after
And
2012, you can whether this will be an additional qualification. In
yes, the qualification for those petitioner, those candidates who are appointed prior to 2012, for them it is not additional it's an additional qualification.
Okay, but Mr. A.K. B. Purkaya still in the council for the petitioner. As well as Mr. N.J. Khatania, Learned Standing Council, Secretary,
Secondary, my lord.
Education, and Mr. B. Gogoi. And we have Learned Standing Council, Finance. Yes, sir. Stop it. Admit, little. All parties are represented? Yes, sir. As all parties are represented and pleadings are complete.
A date,
List
my
the
lord.
matter for hearing on when?
Any date as you look.
When do you want?
Lord,
After
on 22/11, man.
11th,
22/11.
11th of November. That is not a hearing date. It is a Friday, 21st. 21st.
21st.
21st, 11.
Obliged.
36.
My lord, here, my lord, why this petition, my lord? The rule have been challenged, the prescribed qualification and advertisement, my lord, issued by the BTC authority under challenge, my lord.
Pleadings are complete.
My lord,
My lord,
I think BTC, my lord, they have supposed to file affidavit. I took time earlier.
Revenue already filed.
Revenue, they have filed, my lord.
Revenue has filed, isn't it? Who is the respondent number 4?
Respondent number 4, Lordship. I appear on behalf of respondent 4.
3, 4, 5, my lord, train.
5, I appear.
The 1 and 2, my lord, if they wish, they can file, otherwise, my lord, fixed for hearing, my lord.
For
Adjudication. Adjudication.
3,
কি হয়েছে এই কেসটি admission admit the matter, my lord, that fix your hearing, my lord.
3 and 4. How about the 1 and 2 BTC?
Lordship, I'm appearing on behalf of Mr. P. Nayak. Lordship, may kindly allow us 2 weeks' time, we'll file the affidavit.
Okay. Third Mr. M. Saranya, and then it comes to the petitioner. On behalf of Mr. P. Nayak, then the standing counsel BTC. 2 weeks' time?
Lordship.
2 weeks' time is allowed to file.
Earlier they tried, took side 2 times, my lord. This is the last opportunity, my lord.
Yes, after 2 weeks. We'll see. Let
This is
them
the last
come-
chance,
let
my
them
lord.
come with that.
Because, my lord, they have issued the advertisement, only selection process initiated. And they have selected also, my lord, selection has been selected by the petition, my lord. That is, my lord, state, my lord, the selection process. That's why I'm not praying for, my lord, here the interim order, my lord. So, my lord,
After
the last
2
chance of the BTC,
after
my
2
lord.
weeks. Okay, 2 weeks.
My lord, death, my lord.
We'll come up after 2 weeks, otherwise you can make a mention. Huh? Tomorrow, no?
All right.
No, today. Okay, okay.
I pray for a death fix that, my lord.
Okay, list the matter on 1, 2. September.
30. My lord, maybe after 30, my lord.
After that is vacation.
My lord, then before 27, or 27, 28, 28, 27, 8, 9, my lord, I have some different engagement, my lord. I'll be out of court.
Okay, 26th.
I love this, man.
Nine, ordered.
Yes, what is your case, Majumdar?
Lordship, Lordship will find the order. Annexure A is the order passed in the PIL. And Annexure B is the order passed in the contempt petition. So Annexure B is important. And which gives me liberty to file a fresh. Page number 11, Lordship.
Contempt. Yes.
So Lordship, thereafter, when the work has not been completed, I have informed the authority by way of filing the representation which is in the Annexure C, page number 13. Lordship, see in the page number 14, it is in photograph.
Page 14.
1/4 is a photograph. The work is so
We can't make out anything from this photograph.
no, I am not on that because it is not a PIL. I'm just raffling.
No, the issue is the contempt was closed.
Contempt was closed by giving liberty that if the order is not complied within a stipulated time, then liberty was granted to me to file a fresh
proceedings.
proceedings in term of contempt.
That word is not there.
However, it is provided, I may be allowed to read that. However, it is provided that the authorities shall adhere to timing and complete the work within the time limit as stated by themselves in para 3 of the communication dated 6/9/2022. Based upon which this order is passed, on non-compliance of the same, the petitioner would be at liberty to file a fresh proceedings. The content petition stand disposed of, notice discharged.
Initiate. Yes.
So Lordship, what I could understand that the observation of the court, which was observed by the order dated 9/9/2022 passed in a contempt petition, that the liberty is given to me to initiate a fresh contempt proceeding if the assurance given by the authority is not complied with. As because the order passed in the contempt proceedings, so liberty cannot be given to file a fresh PIL.
Okay, when was the order passed? Contempt?
It is on page number 10.
Page 11.
Page 11 relevant portion.
Says 9/9/2022.
9/9/2022.
Supposing we take that period from 9/9/2022
Yes.
under section 20. It will expire on 9/9/2023.
No, there is a
After the initiation of the after the initiation of the construction of the RUP, that was with for 10 months, correct? That was for 10 months.
From the day of the date.
Yeah. So 10 months would complete when? When they are supposed to complete the work?
That is
July.
July 2023.
So by July 2023, if they don't complete the work, then the issue of contempt arises, correct? Then from July 2023 to July 2024, that is 1 year.
Lordship, another point is that that however it is provided that the authorities shall adhere the timing and complete the work within the time limit as stated by themselves in the para 3 of the communication dated 6/9/2022. It is a tender notice. 6/9/2022 is a tender notice and this tender notice says that 14-month time.
Where's the tender notice?
Lordship will find in the page number 15. Period of completion is 14 months. Page 15, Lordship.
Where's the period? Period of completion. Where's this 6-9 communication, 6-9-2022?
Lordship, in the bottom of the page, run date time 6/9/2022,
Where?
page number 15. It is in communication. That communication is a tender document.
Where?
Lordship, the last bottom of the page number 15, last page 15. It is recorded as run time 6/9/2022. Where is it? Somewhere.
No. That is not the communication. I'm talking about this page 11, where this court has recorded the communication of 6-9-2022.
The communication of 6/9/2022. Chakraborty Court communication issued by the senior division and NFL had the requisite amount as per the that is an official communication, Lordship, 6/9/2022. Lordship, if Lordship give me some more time, most probably it is annexed with the affidavit in opposition which the railway have filed. It is because I have not annexed along with my petition.
Okay. Take some time. Okay, on request made by FZ Majumdar, learning counsel for the petition. List after,
Short, very short date, Lordship. I'll find out if
list after 1 week.
Lordship. And Lordship, I may prepare to get a date, Lordship.
List the matter again on 18 then, 18.
Lordship.
Lordship, item number 31 is there, my lord.
How many admission matters are there? Still one. Then we'll sit at two.
Right.
It will be Romero, it will be illegal. Maybe allocate them in time. I can have an additional separate thing, allocate them. Good. Order, huh? Okay. You have a copy of the early orders?
Lordship. Earlier orders, Lordship, I have promised. 22.
No, 5, 66, 53. Here your case is that you are not the resident of,
Not of those two villages, Lordship. I'm
which,
from
which two villages?
Choto Larpang village and then Noboti Lombu Kro
And you are a resident of?
in Haflong. I'm from Haflong. That's about 100 kilometers away.
So you have no personal interest?
No, no. No, Lordship. And then this earlier matter was with regard to Assam Mala project. This is a completely different project.
Yes, Siddharth.
Lordship, my prayer, my humble submission before this honorable court is that let this PIL be converted into writ petition because the petitioner has spread some interim protection also.
What interim protection?
They should not be disturbed. Status quo, that is page 44, Lord.
Who's acquiring the land? Who's carrying out the process of acquisition?
is
The
supposed-
government or this
No.
private company?
The government, Lordship. Dima Assam, Autonomous
Till
Council.
that process has not yet started. It is, but till that it is not started. It's a premature case, Lordship.
Lordship, their communications
There is nothing on
show
record.
that the communications, one letter is there. That is to the, from the Additional Secretary Revenue, Dima Assam,
Page,
Lordship,
page.
is page 68. Annexer 7. The letter says that it is already allotted to Mahabal Cement.
68.
Yes, Lordship.
Nothing is there, Lordship.
Page 68.
Page 68, Annexer 7, Lordship.
Third line, Lordship.
Discussion. Subject is discussion on the matter relating to the proposed side of message so and so.
Lordship, that is on the third line, Lordship will see. You are hereby directed to inform all the villagers, petitioners of a village to be present on the meeting to be held on the 8th of June at the proposed site of the new cement plant allotted to Mahabal Cement Private Limited.
Here the letter indicates that it's already allotted.
Lordship, letter indicates that land has been allotted to Mahabal Cement, but the land which the petitioners are claiming, that land has not been allotted, Lordship, as per the instructions which I have received over telephone from the council. That is the government cast land. There is some government cast land which are being allotted to this cement company for setting up the plant.
There is another letter to the other village also, Lordship. That is Annexer 10 to the Choto Larpeng village.
Page.
Annexer 10, this is page 80, Lordship.
In August. This is 7 June. These are two different villages.
Yes, Lordship. They have now, the cement company has now entered the land of this Choto Larpeng village, Lordship. I have also annexed the photos on the last page, Lordship, Annex 18, page 96.
You get some specific instructions and come back.
Lordship, I will, but if Lordship peruse the photos which are annexed in page 96, it seems that there is no houses, nothing is there, only the vacant land, about which I am also mentioning that it's a council cast land. Yes, Lord. Yes, I will.
Okay, heard, Mr.
Yeah, I got that.
Yeah, Katha, then a council for the petition. Mr. RM Das. Then standing council, NC Hills. Shall take instructions as to whether the acquisition process has started in respect of the two villages, namely
Nobody Longkukru and
Nobdi Longkukro and Choto Larping revenue villages at Umrangso area of Limahas. Oh, okay, yeah. For setting up of the cement plant by the responding number 7.
Notice maybe, notice or I will have.
Just include the info, we are not issuing notice.
Lordship till the next date, some protection.
No, let me. How much time will you require?
2 weeks, Lord.
Lordship, they will continue.
How far is it? Then you take a week's time.
No, I will.
Listen, the matter up to 1.
27.
One.
27.
This is covered by the judgment of the Honorable Division Bench in Dilip Talukdar. They want a promotion.
From executor.
Yes, Lordship.
Twenty-seven.
My lord, he's still now in lag, my lord. So matter may come on next week, my lord.
Okay. On request made on behalf of Mr. B.D. Das, the senior counsel for the petition, for the applicant. List up to 1 week.
Yes, one for it.
Okay.
31.
Ship, I appear virtually, my lordship, for item number 31 for petitioner.
Yes.
My lordship, one of the grievance of this petition is about there was a latest amendment in the Finance Act 2024, my lordship. By virtue of that amendment, that entire demand goes up. My submission is that anyway the order was passed without granting the opportunity of being heard to me, and my reply was not heard. The matter may be sent it back for reconsideration, including the latest amendment in the Finance Act 2024. So the
Lordship, here, virus of the section 16(4) of the CGSA and others were challenged, which by the amendment made in Finance Act 2024, all has been covered. With regard to the not hearing of the petitioner before issuing of the so-called notice, that instruction I have not received it yet, Lordship. What was the reason or how it was done?
Kayal, are you filing your affidavit? No, Lordship, since in view of the latest amendment, the grievance of the petition has been already.
Most of it has been fulfilled.
So you want to take instructions?
Only with regard to that so-called notice, Lordship. Assessment process, Lordship.
But Mr. You witness, please.
Venkat Prasad, possibility, my lordship.
Venkata Prasad. We got the Prasad P, learning council, the learning senior council. You're the
No,
senior council,
no, my lordship, I'm.
learning council appealing for the petition. Mr. P. Chakravarti, learned standing council, state GST.
Yes, ma'am. 1
Rest-
week, Lord.
Rest for a short time to enable him to receive instructions as to whether the petitioners were issued show cause notice, correct?
Yes, ma'am.
No, my lordship, opportunity of being heard, my lordship. Notice was given. By the time I filed my,
Subsequent, assessment proceeding has been done. But according to him, there, it was, no opportunity was given.
So you want to take
Only
it,
that
whether
part,
the opportunity, whether,
Yes.
to take an answer as to whether opportunity of hearing was given to the petitioner before passing the impugned order.
Yes, my lord.
List on,
After a week, Lord, about 10 years.
we'll have it on 23rd.
that is fine, my lordship.
Okay.
That is fine.
You want it on 23rd or 25th?
23rd, my lord.
23rd.
Deeply obliged.
37 of supplementary hearing.
Wait, your lordship. The petitioner has been able to procure a certificate from the headmaster of the school issued yesterday and sent it by WhatsApp, lordship. It shows that she has been working continuously.
She participated in the screening process, but she didn't qualify the criteria laid down in the cabinet memorandum. So she has not been accommodated.
But why are you permitting him to hear?
We are not permitting, because my lord, I have talked to the office of the director, my lord. They have contacted the school headmaster of the school till 2021, till the screening process was going on, my lord. That time she was irregularly regular, my lord, but thereafter she was not appearing in the school, my lord. This is the certificate issued by the headmaster, my lord. We have no control over it, my lord. Whether he's giving the certificate by as per the attendance register or not, my lord. Because I have not seen it, my lord. Regarding the no, that I have seen, my lord. I have not seen the register of the school, my lord. So I cannot say, my lord, whether how much it is genuine, my lord. I cannot comment on it, my lord. But regarding, my lord, screening process, she participated in the screening process.
No, that part is. See, the principle is saying that she's continuing to serve us. If she's continuing to serve, then she should be signing on the register, isn't it? Almost produce the register. Then it's part of, oh, we will. Can you produce the attendance register?
Yes, my lord, that I can bring, my lord.
In every technical, do we have to go into all this like this? I think we close it. Hmm? Good. Can you produce by Friday?
Only difficulty, my lord, from 12 to 17, I will not be available.
Can you satisfy someone else?
I can request someone to appear, my lord, but I think personally will not be able to till 17. And regarding Malata, can it be possible to produce the soft copy of the register?
No, but my lord wants is, now you say he is screened and he is not qualified.
Yes, my lord.
So naturally, there is no occasion for that lady, for the appellant to continue in this.
Exactly, my lord.
But now, Secretary has produced.
Yes,
this.
my lord, I have seen,
So either you are correct or Mr. Kutubi is correct.
Yes,
You
ma'am.
have permitted him to, her to continue till date, in spite of all this.
Yes, my lord.
Developments.
Yes, my lord.
The question would be, at least that stipend what is due to her should be paid to.
Yes.
For the period she had so served. You agree to that?
No, I cannot say right now
Then
because
you have to.
I have to verify it. I have to verify it.
Verify it and tell us on Friday.
Well, I Friday, my lord.
This Wednesday, Thursday, Friday,
Coming Friday.
this Friday.
Yes, my lord.
Friday.
Okay, my lord.
Okay. Mr. N.G. Katania, Standing Council, Department of School Education. Submits that as the petitioner, after appearing in the screening test, after appearing in the screening process, was found to be not eligible for appointment as an assistant teacher under the 10% reservation quota, isn't it?
No, my lord. Screening process is
Okay. Was
91,
as an
19,
assistant teacher.
19.
Stop. He also submits that after the year
2021, my lord.
after the year 2021, the petitioner is not attending
Yes, my lord.
is not attending to the said school. Stop. But however, today, however, Mr. R.P. Kakutil, the senior counsel, has produced a certificate dated 10/9/2024, issued by the headmaster, Mohaijan LP School, wherein it is certified that the petitioner is rendering her service since her joining on 13/3/2001 till date. But in that view of the matter, then the standing council higher school education department shall produce the attendance register of the Mohaijan LP School and also clarify before this court as regards the certificate issued by the headmaster Mohaijan LP School dated 10/9/2024. Please again on 13th.
Oblige.
Oblige.
Your lordship, order was passed by your courts only.
Maybe, have you seen the notice?
No.
Then-
But order is passed by your court.
That is correct.
So I mentioned here.
You make a mention before the court number 3 tomorrow.
Obligor.
Item 1 of daily leave order.
May I please, your lordship? On the last occasion, your lordship, a hard copy was asked for your lordship, as the review petition copy was not with me. And at the same order has already been passed to your lordship to provide me one hard copy. But he did not provide me one soft copy at evening time period, your lordship, he sent me, which I already sent to the department, but no hard copy was given to me.
Give, my lord. Yesterday she told me to give, my lord. So yesterday night I sent her by,
I used to remind.
Mr. B. Procastor and the counsel for the petitioner shall provide a hard copy of this review petition to MSP thus within the course of the day. When do you want?
my lord, become on Monday.
Yes, your lordship.
List the matter again on, not Monday, I think Monday, many cases are there, 18th.
18. Oh,
18 to बहुत matter are sir.
next one, yes. Oh, you're waiting like.
Free of
And it-
supplementary.
Deeply obliged.
Item.
In this matter, we have done our part.
In this case, a little accommodation will be required today, my lord. Mr. Learned AG is held up in another matter in an outline bench matter. My lord, kindly fix the matter on Friday, my lord, day after tomorrow, 13th.
Friday.
Yes.
Okay,
19.
on request, but on behalf of the cycle. Okay, heard, Mr.
It cannot.
HK not learned counsel for the petition on request made on behalf of the cycle, the Advocate General also. Please again on 13th.
13th.
My lord, can be taken up on a fixed time, 3 o'clock or.
Okay, that day you mentioned it.
Yes, sir.
Pertaining to our matter, your lordship, item 1, your lordship, can it be on 20?
20,
Yes, your lordship.
okay.
Deeply obliged.
2 of daily leave. Hearing.
May please tell us. Also, as per the last order, I was required to provide a guideline of conducting of DPC. Cases, lordship. Under amended rule 36(6). The promotees are so to be fixed over the direct, that is the case. Where lordship, when our case is that, when the vacancy arose at 2012. The recruitment
no.
will be given there.
You're supposed to produce.
Yes, no, just refreshing the facts. Lordship, we have, against my letter, we have received one clarification from the department, Lordship, and it is very much clear, Lordship. If Lordship permits, I want to just say, Lordship, that appointments were made under direct recruitment in compliance of various order, especially order dated so passed by the Honorable High Court in various writ petition. Writ petition number 3283/2009, writ petition 32207. Because there are almost 15 to 16 number of writ petition. So by following the direction of the writ petition, that has been done, Lordship. And it is a case, it's an exceptional case, Lordship. It's an exceptional case, and you go and challenge the direction of those writ petition.
You're not challenging anything here. What we are challenging is here.
Their case is that they have been given appointment in 2013, and the direct recruitment and the direct recruitment were given in 2012, where the vacancy arose in the same area. But that is the, we have, there was some direction upon us, by following that direction, except only we have done that, Lordship. And in 2006 also, Lordship, the vacancy arose in 2006, Lordship, and in that case, Lordship, we have fixed over the promotion about direct recruitment, Lordship.
Let us see your.
Yes, Lordship. It is a totally exceptional case.
You have the record also?
Lordship, record I don't have.
You're supposed to produce the records. That was in the front of.
Lordship, against my letter, Lordship, Lordship, I have duly communicated the order of this court to them. Well, this clarification I have received.
This is not a guideline.
But this is not a guideline. This is the explanation why we have done that, why we have taken that step, Lordship, why we have given the direct recruitment.
No, that is fine. That is fine. That clarification that this court, we can take this into notice. But the records.
Record, they have not, we have duly communicated to my letter also.
Then you produce the records, at least.
But again, I'll write to them, sir, not a problem. I'll write to them, Lordship, again, because I already have written to them.
But this is taking so long, why don't you?
I think with the help of the, I thought the Lordship could be able to dispose of the matter. Because these are the direction. These are the judicial orders, Lordship, following which the department has done. I thought that it will be sufficient enough for Lordship to come to a logical conclusion.
Where's this order 6/6/2012? Read petition in this,
In the, I think that
has it been annexed in this list?
the petition.
No. No, Lordship, here.
The order dated 6/6/2012 passed by this court in this batch of writ petitions.
Lordship.
Not, it is not an ex.
No, not
It
here.
is- it is- It is on this basis that you took these steps, isn't it? According to your,
That is as per the instruction, Lordship.
as per your instruction,
Lord.
as per this court's order dated
Yes, yes,
6/6/2012, you have taken these following
Yes,
steps.
yes.
So where is this order 6/6/2012 so that this court can also examine the matter? These are coming in small bits.
The Lordship, if I may, Lordship, the Lordship here, the matter is not related to the direct recruitment's appointment. There is no question, there is no challenge to that effect. What is the challenge here is that after even when there are vacancies available, the promotees were not given the promotion. They took a very long time. They were selection committee set on numerous occasions in the 2012 itself. Every time on one plea or the other, they were postponing it.
My brother is missing one thing also. There is a ratio also 75 and 25 ratio.
That part.
That we have demonstrated here, Lordship. Our chart is there.
The Lordship wanted to,
Cataloging
I
everything.
can produce the letter along with that. And also
records.
yes, and along the records. I'll begin that.
But Mr. Air Governor.
Yeah, good.
Learned Counsel for the Bench. Mr. C.K. Vara, Learned Governor Advocate Assam. It's allowed how much time?
2 weeks time, so the record.
2 weeks time to produce the records. As well as the order dated 6/6/2012 passed by this court. In WBC number 3283/2009 and a batch of other writ petitions.
Fixed that may be given, Lordship.
You get all these orders, it's
All the
already here,
orders.
you find it out. List on,
Please. To the third, not 30th, 20, 27th of September.
If I may pray you, Lordship, the last week might be declared as a miscellaneous week. Since it will require some
Okay,
time.
yeah. The last.
Lordship, let in that case, we fix it after vacation.
I have no issue, but subject to your Lordship.
Because last week will be a motion day.
Last week will be a motion day.
16 July.
Lordship may just mention that a copy of this
July, Lordship.
maybe given to us also.
October, I think. 16 October, not July.
Oh, sorry.
16th of October.
Go to next year.
After vacation,
Yes.
After vacation.
22nd October.
Yeah.
You finish a copy of this to him also.
Yes, sir. In fact, I thought that I should write a letter, but I thought that it is better to place it before the court, then after the court requires that the record is necessary. I mean, and that is the only reason, Lordship. Most of